I will say that Trump has already that same day. So that opinion was issued yesterday and the order was issued yesterday. Trump has already filed an appeal. Well, he's filed a notice of appeal, to be specific. So he's informed this court that they intend to appeal, and they've asked for a stay, a freezing of the order, eliminating all those tariffs, those 33% or so of Trump's tariffs he's put in place since he came into office. Let's see, is that just... Yeah, and so this was filed yesterday, right after the opinion. We're notifying you that we're going to be appealing this decision. We'd like a stay of your order while we're appealing it. As of the start of today's show, a couple of hours ago, I hadn't seen a response from the court to that. Ultimately, of course, I suppose this will end up back at the Supreme Court. Now, obviously, well, it's obvious to me, this document was put together very quickly. Like one giveaway, for example, is they have... in their argument for the stay, they have this little table of contents. 1, 2, 3, 4. In fact, there's 5 sections. There has to be 5 sections because here they have legal standards, and there's 4 legal standards. Irreparable for a stay. Irreparable harm, won't injure others, in the public interest, and likelihood to win on the merits. When I looked at this table of contents, I was like, well, where the hell is likelihood to win on the merits? That's actually the most important one. I would put that one, that would be the first one I would address. And I don't see it here. And I'm like, well, they're going to get denied the stay if they didn't argue the most important criteria for a stay is likelihood to win on the merits. Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you. So as I read through all this, let's see, Section 1, Section 2, Section 3, Section 4, public interest, and then I keep going, and there's a second Section 4, likely to win on the merits. This should, of course, be Section 5, and it wasn't included in the table of contents at all, which, I mean, is not legally important, but it suggests to me this was shoveled together pretty quickly. And of course, they argue that they're likely to win on the merits. Let's see, how long is this? This is only a couple pages. So let's look at this. This is basically Trump's initial response on the merits to this insane opinion by this court. So this might be of interest. And it's not very long. And I'm not sure how else I would cover it. Let's see. Oh, that's public interest. Here we go. The U.S., meaning Trump, is likely to succeed on appeal to win on the merits. The court should also stay its order because we're likely to prevail on appeal. These executive orders are valid exercises of the broad authority Congress granted the president in the IEEPA. It authorizes the president to regulate importation. The court held, in contravention of binding precedent, that the president acted outside his delegated authority when implementing the reciprocal tariffs. The court also improperly reviewed the merits of the president's chosen means to address the national emergency related to the fentanyl traffic. This is the deal with language, holding that those tariffs fell outside the authority granted by IEEPA. There's a substantial likelihood that the Federal Circuit, the appellate court after this Court of International Trade, that the Federal Circuit will disagree with this court's decision on appeal. That is precisely what occurred in Yoshida, as we covered. After the trial court originally held that regulate importation language in the Trading with Enemies Act did not authorize presidential tariffs, the appellate court reversed, just like they're going to reverse you guys. The Federal Circuit's appellate predecessor concluded the very same language that today exists in the IEEPA gave president the power to impose an import tariff surcharge. Although this court agrees that Yoshida concluded that regulate importation authorizes tariffs, it determined that Yoshida upheld the tariffs on the basis they were limited, which is quite different from imposing whatever tariff rates he deems desirable. Again, that straw man argument again. The court concluded IEEPA's text must be read narrowly to not authorize reciprocal tariffs in order to avoid separation of powers and non-delegation concerns. The court reached this conclusion without explaining why the major questions doctrine could apply here or identifying any similar law that raised non-delegation problems. The court's review of the president's chosen means, that's a political question, chosen means to address the threats he identified, contravened Federal Circuit precedent that, following the Supreme Court's lead, has repeatedly concluded that the president's motives, his reasoning, his finding of facts requiring the action, and his judgment are immune from judicial scrutiny. And even if the court could review the question, the court did not justify its conclusion that IEEPA does not permit the use of tariffs to pressure another country to deal with a problem within that country. The Federal Circuit, the appeals court, will review questions regarding the interpretation of IEEPA, presidential powers, and constitutional matters de novo, not bound by what this court ordered, and is likely to hold that the president acted within his properly dedicated authority and did not clearly misconstrue IEEPA in imposing the challenged tariffs. This court should grant a stay pending appeal. Okay. So that's their kind of top shelf counter argument to this opinion. I think it's dead on. Dead on. Dead on. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.